My name is Ryan John Hart. May I ask a question, Your Honor?
No, you may not.
My name is Ryan John Family Hart.
I don't have anyone on my docket listed as Ryan John Family of Hart.
This man appeared in court seeking to represent himself, but repeatedly dodged basic questions, claiming he was only the representative. Judge instantly shut down his attempt to represent himself.
You get to tell me whether or not that's your name. If it's not, then I need to call a different matter and bring somebody else into my hearing room.
I'm the representative of that entity, yes.
That's not an answer, sir. Your name is either Ryan John Hart, in which case you're invited to participate in the proceeding today. Tell me your name so that I can determine whether or not you're the proper person to be called in this case.
My name is Ryan John Hart. May I ask a question, Your Honor?
No, you may not. I'm turning to the motion to have attorney withdraw and to have you represent yourself, Mr. Hart. The court does not find that motion to be well placed, and I'm not going to prevent it. And the reason is there are several steps that need to be taken in order for you to be able to assert your right to represent yourself. You were found both competent and criminally responsible by the court after assistance from the Center for Forensic Psychiatry and after an in-depth intervention and interview by them. Your attorney explained that he was somewhat conflicted. You had wanted him to file various different motions, which the attorney did not find were supported by law. I told Mr. Seeger that as the attorney, he and he alone chooses which motions are to be filed and which are supportable by fact. If you were representing yourself, you would not be constrained in the way that he is. It would allow you to file whatever frivolous motions, I'm using that word, Mr. Seeger didn't, whatever frivolous motions you wanted to. And you would not express a knowing, confident, and voluntary understanding of those things. If you were permitted to represent yourself, you would make the court's administration of justice difficult. You would delay matters. You would be disruptive, would be unduly inconvenient to the court and the court's operation of its business.
Your Honor, Your Honor, I have something to say.
You don't get to decide when things are said. That's again part of the issue.
The judge has not let me speak at all.
Mr. Hart, this will not be an argument. This case will not proceed by me talking over you or you talking over me. Court proceedings by law, and they're to be in a specific order, and that order is dictated by the trial court judge. That's me. It's not dictated by an individual who's charged with criminal offenses, you. I don't particularly have any care as to whether or not you're free on bond or whether or not you sit next door. I'm going to set this matter for a new hearing after I hear from your attorney and from the prosecutor. At the next hearing in person, I'm going to view it as a violation of your bond conditions, which includes me revoking your bond and you sitting next door. Because as you've demonstrated, the only way I can control the proceedings right now is to mute you so that you can't speak over me. All right, the court will set this matter for a status conference next month. I will require that everyone in this matter be in person for the reasons I've already explained. Mr. Hart, you're free to sign off now. I expect you'll talk with your attorney and be here in person next month. You'll get a notice in the mail.